first case is Thompson versus Thompson. Each party will have 15 minutes to present their argument. Counsel, or Ms. Thompson, you may reserve time for rebuttal up to 5 minutes. You know how long you'd like to reserve?
Let's set it at 5, and if I go over, we'll just...
Okay. Well, what'll happen is I'll set it for 5 minutes for rebuttal, so you know I'll be keeping the time up here. You get about a minute left, I'll let you know there's a minute left, and I'll tell you when time is up. If you keep talking, that will just come off the rebuttal time. So if you talk for additional 2 minutes, instead of 5 minutes, you have 3 minutes for rebuttal. You understand?
Okay, yep.
All right, very good. The argument are being recorded, so when you come up today, introduce yourself for the record. Make sure you stay behind the podium because we're visually and audio recording you, so let's make sure you stay there so we can hear and see you. If in this case, I don't know that you really do have the need to refer to any child or victim or anyone like that, if you do, refer by initials, and we appreciate that for the record. We've read your brief otherwise and are ready to proceed whenever you are.
Thank you.
Thank you.
My name is Matt Thompson. I am the appellant, and I am appearing pro se. I've watched some videos of arguments before this court, and generally people start out by giving a summary of the proceedings below. In this case, I have no idea how to describe what is going on in the trial court below. I don't believe there is a proceeding being conducted. I don't think opposing counsel can tell you what proceeding is being conducted. And no matter how much time you spend looking at the record of this case or the initial filing, I don't think this court can say what proceeding is being conducted. Having said that, on April 12th, this court accepted jurisdiction over the contempt charge and any other final orders under 250502. So I'd like to address first the contempt charge. The merits. First, 270502 requires a lawful order. The order for which I'm being held in contempt is not a lawful order. I'll read the order. It's 2 lines. Upon consideration of plaintiff's motion and defendant's response, the following interim orders are issued. Both parties are ordered to submit to a psychological evaluation at their cost within 30 days of this order and to submit the results of that evaluation to the court. I objected that the order was not lawful because it did not comply with Civil Rule 35. Civil Rule 35 requires time, place, manner, conditions, scope, examiner, finding of in controversy, and a good cause. And that is from In Re Guardianship of Johnson. It's also in the Civil Rule itself. There was also no opportunity to be heard. There was literally no hearing before the court ordered this order. So if there's no hearing, there could certainly be no evidence for any of those findings to take place. In addition, Civil Rule 37B1 explicitly forbids contempt for noncompliance with psychological order, with an order to submit to a psychological evaluation. So the order is an unlawful order. On its merits, the contempt charge should be dismissed, or reversed, whatever. In addition, looking at the contempt charge itself, the magistrate's order, the adopting judgment of the court, found $1,000 in attorney fees. Magically, in the judgment dated January 31st, from which this appeal is taken, the court increased it to $5,000. It combined it with $4,000, probably from either a motion for attorney fees or sanctions, which was granted again with no hearing whatsoever. None. No evidence taken on that, yet it's added into the purge conditions of the contempt. Everything about the contempt on its merits is completely unlawful. Although contempt is generally immediately appealable as a final order, this assumes a contempt order was entered in the proper exercise of jurisdiction. And now we get to the real meat of what I'm here for. The trial court lacked jurisdiction to issue the contempt order, as well as many other orders and judgments. When a court lacks jurisdiction, all orders and judgments are void ab initio. This court does not have jurisdiction over void orders under Article 4, Section 3 of the Ohio Constitution, and that's stated in State Ex Rel. Dahlman v. Court of Common Pleas, cited in my brief. Jurisdictional problems. First, the Domestic Relations Division is a court of common pleas. it first, before any statute makes it domestic relations or any proceedings are defined, it is constitutionally a court of common pleas. In order to invoke that court's jurisdiction, pleading requirements must be met for a statutorily defined proceeding. The pleading in this case, filed on May 11th or 12th of 2022, does not plead any proceeding defined under law. In fact, it pleads what it purports to suggest as two distinct proceedings in the alternative. It says, first we want to terminate the shared parenting plan. It's a motion to terminate the shared parenting plan, but in the alternative, modify the allocation of parental rights and responsibilities. That provides no notice of the proceeding at all because it doesn't tell us what proceeding is. Therein lies my confusion, her confusion, and what will be this court's confusion. In Supreme Court, Fisher v. Hazenjagger, paragraph 32, the last sentence, two different standards cannot be applied to the same situation. This is a constitutional violation. We don't have cases. You've all been on the panel for a significant amount of time. I'm sure you've never had a case where you couldn't determine whether it was a civil case or a criminal case. That's because, and even when you go to file at the clerk of courts, at least in Lorain County, they designate civil cases starting with a 24CV and a criminal case 24CR. Two sets of rules apply depending on which it is. In this proceeding, who knows what's being applied? Actually, the trial court says civil rules don't apply. So, you cannot plead, even if the motion to terminate, even if there was such thing as a termination proceeding of a shared parenting plan, which there isn't, but even if there was, you can't plead both in the alternative because they have different sets of rules. Both have requirements before proceeding into divisions A, B, and C. So when a court doesn't have jurisdiction because the pleading document does not properly invoke a statutorily defined proceeding, all judgments and orders of that court are void ab initio, and both the appeal and the trial court case must be dismissed because this court doesn't have jurisdiction over void orders. Plaintiff's initial pleading, the alternative motion, to invoke the trial court's jurisdiction does not even satisfy the pleading requirements of a proceeding pursuant to 310904E1A, which is the proceeding to modify custody. It states only a change in circumstances. It does not specify whether it's the child's circumstances or either of the parents of the shared parenting plan. And it does not plead at all 310904E1A with the I, or I. Doesn't plead any of those three. That is a requirement to invoke the court's jurisdiction for a proceeding under 310904E1A. More nervous than I thought I'd be. It's hard to speak. So that also, because it did not sufficiently invoke the court's jurisdiction to what we know actually is a proceeding, that results in all orders being void ab initio, and both the appeal and the trial court case must be dismissed. There is no such thing as a proceeding to terminate a shared parenting plan. I understand that courts across this state are conducting what they consider to be, well, I don't know that they're conducting these proceedings, but they are terminating shared parenting plans. But if that defined a proceeding, what are the pleading requirements? Because under the first sentence of 310904E2C, the first sentence, which I would suppose would be the applicable one for my situation where it's supposedly agreed to, that proceeding, if it's a proceeding, can be evoked merely upon request of one of the parents. What kind of a right is it if it can be destroyed simply by the request of someone else with no standard whatsoever? I would suggest to this court that that is not a proceeding, but the authorization to terminate a shared parenting plan under paragraph C is only within jurisdiction invoked pursuant to 310904E2A, which
Got
requires,
about a minute of time left. Ms. Thompson.
okay, which requires a joint filing by both parents of proposed modifications. That actually doesn't even matter, because no matter what's going on, we know the Supreme Court has said, and everybody agrees, post-decree proceedings are defined and controlled by Division E of 310904. As I said at the top, not one of us can look at the record of this case and say, it's this, or it's this, or it's this. Nothing has been done pursuant to Division E. Nothing. The court has exercised jurisdiction under Division A, B, C, but nothing under Division E. It has made none of the prerequisite jurisdictional requirements under Division E. And
You're now getting into your rebuttal time, Mr. Thompson.
okay, I'll just be a quick. And then, so also I just want to say, on the guardian ad litem appointment specifically, throwing away every jurisdictional problem so far, 310904B2 requires the interview of the child to confer jurisdiction in a domestic relations proceeding. It's different than juvenile court. They have different requirements. But in domestic relations, you're allocating rights between parents. Parents reign supreme. The court just can't willy-nilly appoint a guardian ad litem over a 3-year-old. It's the parents. And the statute recognizes that. The statute constricts jurisdiction only if the court intends to interview the child. I'll reserve the rest of my time. Thank you.
Thank you.
Good morning, Your Honor. Giovanna Bremke on behalf of Ms. Thompson. I do want to address some preliminary matters. There was just some discussion and there's some confusion about the procedure, and inferring that I was confused. I'm certainly not confused. I know why we're here. Mr. Thompson has appealed a decision that relates to 3 magistrates' decisions. Those decisions are from June 1st of 2023, July 7th of 2023, and July 21st of 2023. 2 of those, July 7th and July 21st of 2023, those decisions were objected to before the trial court without providing any transcript. So the trial court presumed regularity, just like this court should, and should not even address those 2 orders. I will focus for that reason on the June 1st, 2023 entry, or objection that there was a transcript for.
Could I interrupt you just for a second? Sure. Were there actually hearings held that there were transcripts necessary for? Were there evidentiary hearings held?
I believe on those, yes.
On all of them that you're saying there's no transcript for?
Yes, yes, I believe so.
What about the argument that he makes that you don't need transcript for legal issues if it's a de novo review?
He's appealing things as my second argument that are not a final appealable order, so it's not even, he's appealing, he's got up here and said that the statutes are unconstitutional. There's not even been a final decision in this case. In fact, they haven't even gotten to discovery because he fails to comply with discovery. That's essentially what this contempt is about. He fails to submit to discovery. So, I mean, my response to that would be it's not appropriate for this court to even consider because we're not even at a final appealable order. And lastly, I would ask for attorney's fees for the continued and repeated frivolous conduct and the repeated arguments that have already been addressed. Again, I'll focus most of my time on the June 1st entry. The June 1st objection, the June 1st decision surrounds an ex parte motion to suspend parenting time for Mr. Thompson failing to cooperate with the guardian ad litem's investigation. Additionally, the guardian ad litem came to the court and said that he was concerned about the child because the child sounds stressed, that the child had to endure conversations between the mother and father, and asked for suspension of the parenting time, which was granted on an ex parte basis, but then that part of it was reversed. So Mr. Thompson actually prevailed on that, at the hearing on the decision that he's objecting to. The only thing in that I can tell from his filings is that he does not want to communicate through the Talking Parenting app. Again, that is a, these are all post-decree filings, but that is, certainly not a final appealable order, a decision to talk through the Talking Parenting app.
So you view that as similar to a temporary order in this case?
Yes,
As the court's
absolutely.
not made a final decision on what to do about the shared parenting.
Absolutely. There hasn't been a final decision on any decision, because again, they can't get to that point without Mr. Thompson filing an appeal to this court and then to the Supreme Court, without him filing, just last week, the week before, he filed for emergency sanctions for things that aren't even before this court. Again, maybe he's confused about the procedure, but I'm not. The only thing that is properly before this court is a June 1st entry, and it's not properly before the court because it's not a final appealable order.
Did the court style it a temporary order? I don't recall from the record, in that order on the Talking Parents app. Do they style it a temporary order, or do they just call it order? How do they call their order? What's the form of when the judge makes a decision to adopt that?
I don't recall whether it says temporary orders, but what it was, again, it was an ex parte motion by the guardian, and then it was the review of the ex parte motion. So that's where to address that, which again, he prevailed and got his parenting time back. The only thing in there that I believe that he's bringing to this court is the decision about the Talking Parenting app.
Did either of the parties at the magistrate hearing or the ex parte hearing ask for there to be a Talking Parent app order?
I don't recall whether it was, but I do know that the guardian, could have been a discussion of the guardian, but the guardian again did suggest that the child was stressed when he had to endure the discussions between the mother and the father. So that's certainly what addresses that issue, and would certainly be within the best interest of the child and at the suggestion of the guardian who's there for the best interest of the child. Just to address his other issues about jurisdiction, this isn't a final appealable order. There's nothing for this court to address regarding jurisdiction. However, there was an assertion in her filing that she wanted the shared parenting terminated because of an inability to co-parent. However, Mr. Thompson fails to comply with discovery, so there's no way for them to get to the decision, or to get to, to proceed in this case, because he won't submit to a psychological evaluation, and he won't comply with written discovery. As far as the psychological evaluation, Mr. Thompson, and I believe he indicated to this court just now, although he didn't give a date, that he thinks that the underlying decision about the psychological evaluation is invalid, whatever term he used. But that decision was a September 1st of 2022 order. So again, that's not properly before this court. What he's suggesting now is the contempt be related to that order. That order has run its course. He said he's objected to it. He's continues to argue the same arguments that he's already flushed out and already appealed. That is a valid order in the eyes of the court, and he has no other legal remedy with regards to that order. So again, that's not something properly before the court. Mr. Thompson, in these filings that he still suggests victim status under Marcy's law, even though this court and other courts have denied him that status. So again, we would ask that you affirm the trial court's decision, or actually just dismiss it because for lack of final appealable order, and to order attorney's fees for the frivolous conduct in this matter. Thank you.
Thank you. You have a little over 4 minutes for rebuttal time, Mr. Thompson.
Okay, thank you. I said she didn't know what proceeding. I can't say what's in her head, but I know what she said. She didn't say this was a proceeding to terminate a shared parenting plan. She didn't say this was a proceeding to modify. She just said this isn't a final appealable order. Well, let's talk about final appealable orders. Revised Code Section 250502 is the statute authorizing this court to distinguish between those orders that this court has jurisdiction over now versus those orders that this court has jurisdiction over at some point in the future. This court, no matter what any statute says, because statutes cannot convert void orders into lawful appealable orders, this court cannot apply 250502 to a void order. That's why it's so important that every court must determine its jurisdiction before proceeding. You cannot apply a statute to say, no, this void order is not a final order, but we'll have jurisdiction at some point in the future, because you won't. There's never a time this court's going to have jurisdiction. So the final order analysis is completely inapplicable. The ex parte order was vacated, it was not reversed. The court never had jurisdiction in the first place, it was vacated. And as far as not being final appealable orders, I agree. The disposition of this case, if you agree with me, is this appeal should be dismissed. But it shouldn't be dismissed for lack of final appealable order. Because you need to prove, you need to find that the trial court actually had jurisdiction to issue the orders it issued. You have to, what proceeding within which was the court exercising jurisdiction to do anything? What if it's a proceeding to terminate? Was the shared parenting plan terminated? No, it wasn't. 310904E2D says upon the termination, then the court can go figure out the best interest of the child. And I want to get to Davis. Well, I cited in my brief Davis v. Fleckinger, where the Supreme Court says these are the barriers that must be hurdled before exercising jurisdiction and determining the best interest of the child. And that's for a modification. Final appealable order analysis doesn't apply. The court hasn't had jurisdiction from the beginning. If this court determines that the pleading document, the initial pleading, is sufficient, then okay, the court had jurisdiction to begin, but everything it's done since then never complied with Division E, so then this court would have to wipe everything out and kick it back to the trial court to continue in whatever proceeding supposedly is being conducted, starting essentially from the beginning, because it never conducted any proceeding.
About a minute left in your rebuttal time.
Okay, I'm good. Any questions? Thank you very much.
Thank you, Mr. Thompson. The court will take the matter under advisement and will issue a decision in due course. When that decision is reached, it will be mailed to by the clerk of court and will also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your communication.